Good afternoon, everyone, and welcome to the 20th edition of our Expo Talks. Today, we will speak about the intellectual property law protection with our expert today, Mr. Tom Heremans, who is an attorney at CMS Law Office, and he is indeed expert in copyright, trademark, and patent law, and it will tell you everything you need to know about those three topics and how to protect them into your exports. Mr. Hermans, the floor is yours.
Okay, thank you. So welcome everybody. My name is Tom Heremans. I'm an attorney with CMS in Brussels, and I'm specializing in intellectual property law. And I will guide you today through the main intellectual property rights in Belgium, but also on the European level. I try to move a little bit the image here. So, okay. So what I will talk about to you today is about the main intellectual property laws, which are copyright law, trademark law, and patent law. But I will also give you some more information about other intellectual property rights, because these three are the most important ones, the main intellectual property rights. But there are a few more. Since we are living in a technology age, you can imagine that also the other intellectual property rights are becoming more and more important. And I will also say a word about the remedies, because it's good to have intellectual property rights, to acquire those rights, but you also should know how you can use them to prevent your competitors from infringing your intellectual property rights. And at the end, I will have a brief conclusion, a few remarks that you can take away with you. So the first question is, of course, what are intellectual property rights? Intellectual property rights are exclusive rights that are created by the legislator almost all over the world, where the idea of the legislator is, if we want that people create something nice, then we have to write protection for those people, because only if these people create something and they get exclusive rights, only then there will be an incentive for them to create more of those works, which will be to the benefit of everybody. And if we give exclusive rights to the creators, then these creators can license these rights to other people or to other companies, and they can then get reasonable compensation for the work they are doing. That's the rationale behind it. We give exclusive rights to people as an incentive to create more works which is beneficial to all of us. But the general principle in our society is not having intellectual property rights. The main principle that we have in our capitalistic society is that there is freedom. There's a lot of freedom, a lot of rights and freedoms, and one of those rights and freedoms is the right to engage in any undertaking, in any economic activity that you would like. So you do not have to ask a permission to the government if you want to open a shop, or you want to this or you want to do that. Of course, there are some permits that may be required for this or that, but the main principle is that there's a freedom that you can engage in all the activities that you want. And the exception to that is that for some areas you need a permission, for some areas you need this, for some areas you need that. And of course, one of these exceptions is our intellectual property rights, because these are exclusive rights that are given to one person or to one undertaking, and that undertaking can then prevent others from using their creations. One of the lawyers that is currently at the Supreme Court in Belgium said that the intellectual property rights are islands of exclusive rights in an ocean of free competition. So as such, there is free competition, which also means you can look around, you can see what your competitors are doing, you can get inspiration from what they are doing, and you can engage in the same activities as what they are doing if you think that will be beneficial to you. So there is a freedom to copy, to imitate, and that freedom to copy and to imitate is limited by the intellectual property rights on the one hand, but also by the rules of misleading advertisement, for instance. But the principle is freedom to do what you want, to copy, to get inspiration, to see what's going on the market and to do the same thing. And the exception is then, watch out, you should not enter into the area of the intellectual property rights of your competitor. So these are the main principles, and I will explain them a little bit more in concrete by going into the different rights that we will discuss. And the first right that we will discuss is copyright. Copyright is the law of the authors. It's the law that protects people who make nice creations. And what is then protected by copyright law? It used to be in Belgium that it was decided by the Berne Convention, which dates back to 1886. This Berne Convention is still applicable. It has been transposed into Belgian law in the Belgian Copyright Act, and now the Belgian Copyright Act is part of Book 11 of the Code of Economic Law. And since copyright law is more and more an harmonized area of law within the European Union, where the European legislator believes that the copyright protection offered in different member states should be more or less the same in all those member states. And as a result of that, the question what is exactly protected by copyright and what is not, if there are discussions, if there is interpretation, it is up to the European Court of Justice as the last resort to take a decision. And the European Court of Justice said, now, what is exactly a work of authorship that is protected by copyright law? Well, the European Court said it should be an intellectual creation of the author, reflecting his personality and expressing his free and creative choices in the production of his work. So this is now the standard since 10 years. It is now the standard to see, okay, is my work protected by copyright law, yes or no? Then we have to see if it's an intellectual creation of the author, reflecting his personality and expressing his free and creative choices. So if you make something that is merely functional, you want to achieve a certain result to solve a technical problem, well, then there are no free and creative choices in the production and your work will not be protected by copyright law. Now, once we make this creation, and once Mr. Picasso makes this wonderful painting in which he expressed his personality and he used free and creative choices, then his work will be protected as such. So there are no formalities. There is no obligation to file your work with the Belgian Copyright Office, if that would exist, because it doesn't. It is protected merely by the creation. And the protection will last very long, until 70 years after the decease of the author. In some jurisdiction, like in the United States, there's the American Intellectual Property Office. There you can file your work and then it's been put in a register, but it can be helpful if you want to claim damages in a lawsuit in the United States, then it's helpful that your work is registered with the United States Copyright Law Office, but it's not required to get the protection as such. The protection as such in most modern states exists merely through the creation. So if I make this PowerPoint presentation, for instance, well, it will be protected by copyright law to the extent that I made free creative choices to make this PowerPoint, and I do not have to file it to be protected. I can use a little C which indicates that there is a copyright on this, but this is only if I want to do this. It is not mandatory, and it's also not a guarantee. It is not because somebody puts a C and his name on his work that therefore it is protected by copyright law. The court could still find that the work is not sufficiently original and that therefore it does not qualify for copyright law protection. But it can help to show others that you consider your work to be protected. Now, if you have this creation, and I will give some more examples of this creation in the next slides, but if you have this creation, you will have an exclusive right that is protected by copyright law, and you can either exploit the work yourself, and you can publish your own book, you can post your clip on YouTube or on your own website, but you could also use the help of other parties. You could, with your book, you could go to a publisher. With your movie piece, you could go to a record company. With the clip, you could go to a movie company, and so forth. Well, if you do that, then you have to conclude a contract with the other company who will exploit your rights. And the law says to protect the author, these contracts have to be in writing. And this is very important for you and for your companies. If you and your companies, you work with other people who make creations for you, who design your web page, who make a logo for you, who write a user manual, who gives the nice design to the products that you are making, you have to make sure that you have a written contract with them in which it is said that they assign all their intellectual property rights to you because you pay them a certain amount and therefore you will own the rights. Because if you do not do that, and later on the contractual relationship with this person who is making your creations goes wrong, then this person can walk away from you, and he may prevent you from using the creations that you have paid for, because this person will say, well, I made these creations for you, you paid me for that, well, you were allowed to use them to a certain point in time, but since now our contractual relationship has stopped, I do not allow you anymore to use these works in the future, and you could be obliged to take these copyright protected works from your websites, from your letterheads, from your logo, from your products, and so forth. So it's very important that you conclude an agreement as a company with all the people who work with you, including your employees, because even your employees, if they have a creative task within your company, you pay them every month their salary. The law says that there is no assignment of the copyrights of this employee to your company as an employer unless there is a clause in the labor law agreement or a separate clause which says that the employee agrees to assign his copyrights to his employer in the framework of his labor law agreement. So that's very important. You need to have with the author a written agreement. Now let's take a little step back to see what are these creations that are protected. And of course, you will understand that a book of a movie or a record or a painting of Picasso are all protected by copyright law, but the threshold for protection is much lower. It should not be a creation that qualifies as real art that is being shown in the musea. Also, works of applied art can be protected by copyright law. And here you see on the screen the bag of Longchamp. It's a bag that is relatively popular. It's the bag that you can fold and make it much smaller. Well, this bag has been protected by copyright law by the courts here in Brussels. The court said that Longchamp, the French fashion designer, and his employees made a creative work that is a work of authorship, and other companies are not allowed to copy this, for instance, in plastic as a free gift when you buy some chocolates, which has been a case the last couple of years. What is interesting about this bag is that it's protected by copyright law according to the court here in Brussels, but that the court in Ghent in an earlier case had a different opinion, and the court in Ghent ruled that this bag was not really a work of authorship. There were no free and creative choices that were made. It's just a bag that was created with a style that was fashionable at a certain point in time. I just respectfully disagree with the decision of the court in Ghent, but the decision is interesting because it shows that there's always some subjective appreciation, and that the court or a judge in Ghent can find that the creation is not sufficiently original. There were the courts in Brussels have found before that this creation was definitely sufficiently original to be protected. So it's a little bit unfortunate for companies and for persons like you if you want to have certainty when you put something on the market. Will it be protected or will it not be protected? Well, in the end, it's only the judge that can decide, and some judges are more strict than others. And for instance, in Ghent, unfortunately, for the time being, the courts are much more strict and are less willing to grant protection to intellectual property rights for infringements that occur in the Ghent region compared to Brussels or, for instance, Antwerp or Liège or Mons. Another shape that is protected is the shape of the iPod. The iPod is now getting a little bit out of fashion because most people have now telephones which incorporate the music functions. But more than 10 years ago, there was a Chinese knockoff coming on the market in Belgium, which had copied the design of this iPod, which is a very special design. It's a very simple design, so to speak. But the court nevertheless said that it was protected by copyright law, and the Chinese company could not bring a knockoff on the market with the same shape, even if on this Chinese knockoff there was no Apple logo and the word iPod was not used. A similar outcome in the case regarding the Stocker chairs. These are the chairs coming from Scandinavia. Well, also here the court said these chairs qualify for protection under copyright law. Definitely these chairs are at least in part functional, because you need to have certain functions on the chair to protect your back and your butt and so forth. But nevertheless, there are free creative choices that were made by the designer, and therefore this chair is protected. And the last example is then the jeans on the right. It's an Elwood jeans manufactured and sold by G-Star. And G-Star had made an agreement with a French designer, Mr. Morrissey, and he designed these jeans for G-Star. And when G-Star saw copies on the market from Hennes and Mauritz, they sued Hennes and Mauritz, saying that the jeans was an original work of authorship because the different characteristics put all together in one jeans made it an original work. Some of these stitches you may see in other jeans, but bringing them all together in one pair of jeans, that was protected by copyright law. And the first judge, the judge at first instance, he agreed, and he granted an injunction against Hennes and Mauritz. But Hennes and Maurits appealed, and on the appellate level, the Court of Appeals in Antwerp said, oh no, we don't think that this is sufficiently original. It's some stitches, yes, but it's you can see it everywhere in motorcycle pens, for instance, and therefore we believe it's not protected by copyright law. So here again, you see there's some subjectivity in the cases that are not so clear. These are work of applied arts. Sometimes they are recognized and they qualify for protection. Sometimes they don't. Here is an example that I took from the newspaper from like last month. We all know that in Belgium, Tintin and Mr. Hergé are very famous, and the foundation that has the rights of the drawings and designs of Tintin, they closely watch what's going on the market. And if artists, like in this case, a French artist, Monsieur Xavier Marabout, he is making paintings which he's using existing images from other paintings, here the famous Edward Hopper painting, and he puts the Kuifje or Tintin in there together with the sexy woman. And this is something that, of course, the heirs of Hergé do not like, and they have filed suit in France, and they have been filing suits over the last years almost in many European countries, where they exercise the rights and where they say, okay, here is Tintin. He's a creative character that is protected definitely by copyright law. He's been designed by Mr. Hergé, as we can see him right there in the picture. Well, you should not make any reproduction of this person or this character without the consent. And the argument that the artist may raise, saying that, yeah, but I'm just making a new painting in which Kuifje appears. Well, I'm afraid that this will not work, because it nevertheless is a reproduction of the figure, and if you don't have the consent of the original author or his company, then you are not allowed to do this. But we'll see what comes out of it, and whether the free artist spirit will prevail over the copyright law spirit before the courts in France. Another interesting case that we had in Belgium a couple of years ago was this picture that was made by a photographer, Mrs. Katrijne van Giel, of the Flemish politician Jean-Marie de Decker, who is now the mayor of Middelkerke and who wants to open the terraces before the government allows it. So he sees a different character, and this different character of his was well portrayed here in this picture that was made after the elections a couple of years ago, because Mr. Decker did not win the elections as he had hoped. And a few years after this picture that was published in the newspapers, we saw that our famous Belgian painter, Mr. Tuymans, made a painting which is actually a reproduction of the photograph. And also here, Mr. Tuymans believed that he was that he could benefit from the artist exception, but there is no such exception in the law. And the court in Antwerp correctly decided that the painting on the right by Mr. Tuymans is a reproduction. Even if it's made in the own style of Mr. Tuymans, it is still a reproduction of the first picture by Mrs. van Giel, and the court ordered then that penalties should be paid to the photographer. And I think on the appellate level, the parties have reached a settlement. But it shows that you cannot just make a reproduction from a picture in a painting, as it is also not allowed to make a movie out of the book of Harry Potter. If you want to do that, you need to have the consent of Mrs. Rowling, because you make an adaptation of her original copyright protected work. What the modern trends are in copyright law is, for instance, the protection of taste, because you could in theory say that if you make a musical work that sounds nice in the audience ears, you can make a painting that we can see with our eyes and appreciate it. Well, why should people not be allowed in their restaurant as a chef to make a nice creation that you appreciate when you eat it? It's also the sense of eating could also allow you to appreciate the food. And so why would there not be copyright in food? And the Court of Justice here 2 years ago decided, unfortunately, the time is not ripe for that. A food product, the court said, is not a work of authorship. There is no protection offered, which means that if you make a particular food product, like here, the cheese from Holland, Hexenkaas, well, you may give it a particular taste, but other people are allowed to imitate your taste and come on the market with the cheese product, which has more or less the same taste. And you cannot claim that your cheese was protected by copyright law. And an application of that was made last year by the Brussels court here, enterprise court, where a party claimed copyright law on the bread that it had developed, the bio bread, but the court said, no, we cannot grant copyright law protection on the taste of a bread because it's very subjective. It's hard to see what exactly in the scope of protection is, and therefore, for the time being, there's no protection on the taste. So now that I've explained a little bit what works can qualify for protection under copyright law, now it's important to see then what are exactly those copyright laws. And I already said that you should ideally always write a written contract if you want to exploit the copyrights, or if you want to give your copyrights to somebody else who will exploit them. And what should then be in this contract? Well, in these contracts, you should put the rights that you have as an author, to which extent are these rights being assigned or licensed to the other company. And these rights are twofold. You have the economic rights and the moral rights. And the economic rights, you understand, these are the rights that allow the copyright owner to make some money. He can give a license to a publisher or a record company to make CDs or DVDs or post the works on a music platform where people can listen to if they pay royalties. So these are all the reproduction rights on the one hand, and the right of communication to the public on the other hand. Because the reproduction right and the right to communication of the author, these are the two main rights of the copyright owner. Each time you make a creation, as the examples that we have seen on the previous slides, each time you make such a creation, you are entitled to prevent somebody else that has not your consent, from reproducing those works, from making copies, reproductions on the one hand, and from communicating these works to the public by posting them on a website, by showing the works on a big screen for an audience, by showing it on the radio, on television, and so forth. So the communication to the public is one right, the reproduction is the other right. And for these both rights, you can only exploit them, you can only do something with those works if you have the consent of the author, who will then, in most cases, in this written contract, require the payment of a license. Since we are talking about international business, you could ask the question that if you sell a product in France and then somebody brings this product that you sold, that is protected by copyright law, such as a book or a CD, brings this product to Belgium, can you then use your Belgian copyright and saying, well, I have Belgian copyright, it's resulting from book 6 of the Code of Economic Law, and I have not given the consent to bring this product, which is protected by my copyright law, on the Belgian market. Well, here the intellectual property rights come into conflict with the free movement of goods within the European Union. One of the goals of the European Union that we have right now is that there would be a free movement, not only of goods, but also of persons and capital to a certain extent, and so forth. So here, using your Belgian copyright law to say that this product should not be imported from France to Belgium, when you have sold it before in France, that will not work. Here, the courts have said, no, you are not allowed to close the borders and to exercise your copyright separately in each member state of the European Union. If you sell your work in one of the countries of the European Union, then you will have received your royalty, your compensation, and from that moment on, this product, the particular product that you sold, can freely circulate within the European markets. What we call in the legal jargon is that the rights are exhausted. There is exhaustion. You have put it on the market in the European Union, or you allowed your company to put it on the market, and therefore it can freely circulate. So these are the economic rights: the right to reproduce, to copy, and the right to communicate to the public. These are the essential economic rights of the author. And besides that, the author also has moral rights. And moral rights, they are not dealing with the economic position and the money, they are dealing with the name and the reputation of the author. There are three rights. The divulgation right, it's less important. That means that the author is the only person who can say this work is ready now it can be shown to the public. But that's less important in practice. The right of attribution is more important. That's also sometimes called the paternity rights, but in the modern times, paternity rights, maternity rights, I rather use the term attribution right. And this is the right to be recognized as the author of your work You can make sure that your name is put on your work. If you publish a book, the publisher must put your name. If you have the painting, you can put your name yourself. Nobody can take this name away. If you are making movies, at the end of the movie, there should be the list with all the people who created, who co-created this movie and so forth. And then there's the integrity right. That is the right to prevent any change from your work, because you will easily understand that if Picasso makes a nice work with nice colors and nice drawings, well, you cannot just decide to change the color a little bit to make sure that it's better matching with your sofa and your curtains in your living room. No, Picasso made the work as it is, and you are not allowed to change it. Of course, these rights are not absolute. In the advertisement business, for instance, a lot of people create nice advertisement campaigns, movies, posters, clips, and so forth. Well, they can, in the written agreement, agree that their name should not be mentioned in this advertisement spot or poster or whatsoever. So you can renounce to exercise certain rights, which will be common in some industries. The same also with the integrity right, or that right is also not absolute, because if the right would be absolute, that would mean that if you have a nice house designed by your architect and your family composition is changing, you would not be allowed to change a little bit the house and to put an extra garage or an extra glass house in the back. That would not be allowed because you change the initial creation. And therefore, also this right is not absolute. And in case of a dispute, the court must see what can be done and what cannot be done. And the court must balance the moral rights of the architect on the one hand and the real property rights on the house by the owner of the house on the other hand. And in the case that you see there, there is the museum in the Netherlands where the architect made an objection about changes that were going to be made to this museum, and he filed a suit in court, and the court agreed with the architect that the museum was a work of authorship and that the owner of the museum could not just completely change the image of the building, and the architect won his case, and the parties have then settled their case, and they found an arrangement where the initial architect received a considerable amount of money that he was then putting into a fund to promote architectural creations in the Netherlands. So it's a recent case here from the court in The Hague where these moral rights of the architect were recognized. So there are some exceptions to the copyrights. As I said, no right is absolute, and also the copyrights are not absolute. And there are a few of exceptions that are written into the book, in the books of the Code of Economic Law, in book 11 in this case. For instance, you can use quotations for criticism or reviews. You can have short fragments of news reports. You can make a private reproduction, and normally the right to reproduce is one of the economic rights of the author. But if you see a book and you want to make 2 or 3 pages photocopy, you're allowed to do that. It's a private copy. The same is true for the communication to the public. You can make a private communication to the public, and you can show a movie to your family and to your closest friends. If it's a small group, it will not be considered to be a communication to the public for which you need to pay extra royalties. You can also use illustrations for educational, for scientific purposes, something that I'm doing. I'm using a lot of examples in these slides, but it's a part of education to show to you what these cases are all about. And the last, number 6, is also giving rise to some interesting cases. These are the caricature or the parody. Is it allowed to have this caricature or parody? Yes, it is part of our system of freedom of speech and freedom of opinion that you are allowed to give criticism. And on the right-hand side, people who are familiar with Dutch culture will recognize it, because een nijn is a famous Dutch character created by Dick Bruna. And somebody made a nice cartoon which refers to 9/11, the terrorist attacks in New York. And Mr. Bruna did not like this. He filed suit, but in the end he lost because the court said that it was a parody, and this was allowed. A comparable case was started in Belgium that went all the way to the European Court of Justice, and the European Court of Justice says that the extreme right-wing party Vlaams Belang in Flanders has in theory the right to make a parody of the famous Belgian comic strip figures of Suske and Wiske. And they made then the cartoon that you see on the right, which depicts the mayor of Ghent, Mr. Termont, who was the mayor a few years ago, who was distributing the money to foreign people living in the city. And the court said, yes, in theory, the Vlaams Belang, the extreme right-wing party, has the right to make a parody. The freedom of speech is for everybody, of course. But since they are a political party, they are bringing a message that is just not bringing critique to society or whatsoever. They are also bringing a political message, and the heirs of Mr. Willy van der Steen, the author of Suske and Wiske, is entitled to prevent that, because his drawings are now being related to or tied to the extreme right politics of the Vlaams Belang Party, and that is not allowed. So a parody as such is right, but if you're using it for political purposes, it's becoming more difficult, because your political ideas are then reflecting on the original author, and the author could oppose against that. So these are a few words about what copyright law is all about, and I spoke now about traditional copyright law that protects works of authorship. But since the times are changing and the markets are expanding, we are not in the time anymore when the first Berne Convention was adopted on the international level in 1886. We have now other rights, for instance, computer programs. Well, these computer programs are now considered to be part of the copyright law, and a person who is writing a computer program has definitely expressed creative and free choices when making his work, even though his personality is less important. Still, computer programs are recognized as to be protected by copyright law, and if you or your company, you are sometimes using an illegal reproduction of Microsoft or of Adobe, be aware, because these companies do check what's going on, and they regularly file suits and even apply seizures with the bailiff, who is coming then to the companies who are infringing. So you have to be careful. Copyright programs cannot be copied without the permission of the owner of the rights. Also, databases are relatively new, right? They exist since 98, so 20 years. And these are rights that are granted to the producer of a database. It's the company or the enterprise who's investing money in creating this database and keeping it up to date. Well, when you do that, somebody else cannot just copy this database and use it for its own benefit. Also important are the neighboring rights. They have been recognized in Belgium since the Copyright Act of 94, so 26 years. And the neighboring rights are the rights of the musicians, of the actors, of the dancers, the singers, and so forth. So if you want to use a musical work of Michael Jackson on your website as a nice introduction to the products that you would like to sell, well, you have to make sure that you have the consent of the author of the music and the author of the text, which may be Michael Jackson or which may be somebody else, but you will also need the consent of Michael Jackson if he is singing the song, about the people playing the guitars and the drums and the pianos, because they are performing artists, they have their own rights. And you will also, if you use an existing record, you will also need the consent of the producer of this record. And of course, you could say, well, for me, it's impossible to know who all these people are. And that is indeed true. And therefore, you have to contact the collecting societies, because the collecting societies, there you can obtain licenses and you don't have to negotiate with Michael Jackson and his band. Personally, you can go to Sabam for the copyrights. You can go to Playwright for the neighboring rights. Agicoa for the second film rights, Simim for the producer's rights, and Reprobel for the private copyrights. So if you want to use works, you have to see which kind of works these are, and then contact the collecting society, who will offer you their tariffs, and then you can see whether it's worth paying the rate, yes or no. And if you do, then you can use the work of somebody else. If you don't, then you have to create your own works. What is also new is today we have all kinds of works, and Europe is adapting to that. A new copyright directive was adopted last year, and here the copyright directive was granting or is granting rights to the publishers, because the publishers have found out that their works are being used by companies like Google. They are offering aggregate services like Google News, but they do not pay any compensation. And sometimes the authors in Belgium have filed suit against Google and they have won. But it's not only about the authors, it's also the publishers who see that they are having less revenues. And the European legislator has recognized these rights. And the companies like Google, they will in the future have to pay the publishers if they want to use their publications. Besides the rights, they also will have to pay to the authors. And the same applies for video platforms, for instance. We see more and more platforms coming out there. All big technology companies have platforms where people can buy and sell goods or see goods. And YouTube, in the area of copyright law, has always said, like, we do not commit any copyright infringement. We are just offering the platform, and it's the people who are exchanging themselves the content. So we are not liable. And from a strict legal perspective, it can be right. Google does, YouTube, does indeed not know what all these people are posting there. It's also impossible to control everything. They do not know what is protected by copyright law and what not. But on the long run, it remains true that YouTube is a very flourishing business, which making a lot of advertising monies, and the authors whose works are being shown on the platform of YouTube do not receive any compensation for that, because they cannot point out who should be paying what, and therefore Europe has decided that in the near future, if there is protected content on YouTube, YouTube will also have to pay to the copyright owners and to then the collecting societies. And on the right hand side, you see a new kind of work, a non-fungible token. Sorry, there's somebody trying to call me. Sorry. You see a new kind of work, which is the non-fungible tokens, and this work was sold on Christie's for 96 million euros or dollars, probably dollars it was. So it's an electronic work where one artist put together all electronic images, and he sold one original copy for this huge amount. So the person who bought this now has a key where he can view on his own computer this original work, which is saved in the blockchain. But we can also see copies like this one for free, not of course in the same resolution, but still you can see there's a new evolution of copyright protected work that will be distributed and sold via blockchain and similar technologies. But normally, to the extent possible, the traditional copyright rules will apply. Move now to the next slide. Okay, so with this we close the section of copyright law, and we'll go to the second section of trademark law. If there are questions, you can ask them via the chat function. I can respond to them either at the end or in between. I see now that there's a technical question about somebody who's not able to see the presentation on iPad, but I'm afraid I'm not cannot help to solve this technical problem.
We indeed received a few questions. If you don't mind, we can maybe ask them now.
Sure. Yes, sure.
Yes. So there is a question, a general question on where to find the list of all copyrights, trademarks, and patents that are currently protected in the EU or worldwide. Is there a list available on a website?
No, there is, for copyright protected works, there is no list, because I said the copyright protection exists merely to the creation. You do not have to register anything, and as a result, there is no such list. So you cannot have this list. You can search on Google and see if you can find information about the particular work and about the author and see if he's dead for more than 70 years, yes or no, but there is no official list. For trademarks, there is, and I will say a word about that later.
Okay, and there are some websites such as Shutterstock or Pixabay who offer free downloads pictures that you can use normally free of protection. Is it really safe to use those kind of pictures, or is it like you still have to pay attention?
Yeah, I would say that it's always good to pay some attention, because if you use a picture and this share stock or whatever says that it's free of royalties, but you are not sure that they do have the consent of the author and that they can declare in the name of the author that there is no protection granted on this picture. So if you use it, there is always a slight risk that somebody will say he is the author and that you have to pay compensation. But yeah, there is this system of common licenses, and people who say we do not claim our copyright law, you can use it. So yes, it's relatively safe, but not 100%.
Okay, and a last question on design protection for jewelry. How to prove the date of the creation of the design and how to protect your design from that very date?
Yeah. I will say a few words about designs at the end, but if you want to think about the date, something that you can do is, if you are based in Belgium, Netherlands, or Luxembourg, you can go to the website of the Benelux Office for Intellectual Property Law, and there they offer the service of what is called the iDepot, the e-depot in Dutch or e-depot in French, the iDepot, I guess, in English, and that's a service that allows you to upload a picture and to get a stamp on it by the official organization, which is the Benelux Office for Intellectual Property Law. So that's an easy way. It's not very expensive. It works quite well. You could also go to your own notary, but that will be more expensive. He can also take a reproduction in an envelope and put a stamp on it, or you could send a registered letter to yourself with the creation inside, and you do not open this envelope. And if one day you have a problem and discussion about the date, well, you can say, look here on this date, which is the stamp of the post, my creation already existed because it's right in this envelope, and then you can open it in front of the judge. That's also possible.
Okay, so several ways. A last question maybe for now. What is the best way to protect a brand on a national or international level?
Right.
What can
Well,
we use for better protection?
Well, the brand protection, that's actually the chapter that we are going to do right now, because that is the brand refers to a trademark. A trademark is normally a brand, and the trademarks is what we're going to discuss now. So I will give the answer to the question on the next couple of slides.
Okay, perfect.
Okay.
Let's
Okay, so that's a
continue
good.
then.
Thank you. That's a good bridge, so to speak, to the second topic, which is the protection of brands or trademarks. And what are trademarks? Now, trademarks are distinctive signs. Trademarks are signs that allow the public to see where a particular product or service is coming from. So a trademark designates the origin of a product or a service. And the trademark can be valid if it fulfills this function. And you can use the word Apple to designate the origin of computers, telephones, and digital services, yes. There it performs the function of designating the origin, being the product or the service is coming from a company in California somewhere. But you could not use the word or the logo of an apple to designate the origin of fruit or of an apple, because if people see an apple as a fruit, well, it's a generic name of the word apple. It does not allow you to say where this apple that you see in the shop is coming from, because it designates the genus of the product or the service. So the trademark must have a distinctive character. It must allow you to designate the origin of a product of service, and then it can be registered as a trademark. Then you can file it with the Benelux office, for instance. It can be registered, you have to pay the fees, and you have to indicate for which products and service you want to use this trademark. And you can have a trademark like Levi's for painting, but you could also have Levi's for jeans. And so you have to indicate which products and services you claim protection for and in which territory. And once you have registered your trademark, you will have protection for 10 years, but the trademark can be extended. It's not that 70 years after the first use or the first registration, your trademark dies. And the trademark Coca-Cola, which is one of the most powerful trademarks in the world, has been existing since more than 100 years. So there's no expiration of the trademark rights, upon the condition, of course, that every 10 years you pay the fees to the trademark office where you have filed your trademark. And trademarks can be the names like or words like Apple, but it can also be a logo like the Apple logo. It can be a small contrasting tab put on the jeans, on the pocket of a jeans. That's the red tab of Levi's. Even that's a trademark as such, the red tab put on the pocket of a jeans. It's not only the word Levi's, it's a tab as such as well. The trademark can be a color. If you see there on the screen the purple or the lila color, and I ask you like which product do you bring this product into relation? If we refer to chocolates, then you will be able, this is chocolate lila. It's referring to the brands of Leo, for instance, which is all from the company Milka. So this purple color is referring, with regard to chocolate at least, to Milka, and the color as such has been filed as a trademark, and now other chocolate producers are not allowed to sell chocolate products with the same or with a similar color of this purple or lila color. Also, the sound can be protected. If you listen to the radio in Belgium, you sometimes hear advertisements from Proximus with the piano sound by Wim Mertens. That's allowed, and that is a trademark of Proximus. You can also file now MP3 files with the trademark office, or even MP4 files. That's possible. So you could also obtain protection for the roar of the lion of Metro Goldwyn Mayer. There you cannot write in notes like you could do for piano creation, but you can register it on an MP3 or MP4 file, and then it can be protected as a trademark. So trademark is really a variety of signs that you can use upon the condition that they allow you to identify the origin of your products and services. And one of the questions was like, how shall I protect it? In which country shall I protect it? Well, you have to decide indeed if you have this trademark for which area you want to obtain protection. If you are a Belgian company, you can obtain protection not only for Belgium, but immediately for the 3 countries of the Benelux. So there is no Belgian trademark or Luxembourg trademark or Dutch trademark. There is only one single trademark that's offering protection automatically in the 3 countries of the Benelux. And if you are doing a local business, you may say, well, that's enough for us. We only do the filing with the Benelux Trademark Office, and we pay, if you do it yourself online, we pay 248 euros and we are protected. If you think now we are a little bit bigger, we are going to focus more on export, and we also want to export to countries in the EU, for instance, then you can obtain a European trademark. You have to file it also online with the European Intellectual Property Office, which is based in Alicante, but you can do it obviously online. There you can file your trademark, designate the products and services for which your mark is valid, and if the EU IPO registers your mark, it offers protection automatically in the whole 27 member states of the European Union. It used to be also that the UK was part of it. Now UK is not part of it anymore. So if you want to obtain protection in the UK, you will also have to file your trademark separately in the United Kingdom and pay the appropriate fees in the United Kingdom. If you already had your trademark in the European Union before the Brexit, then you will have now 2 trademarks. One is the same trademark valid in the European Union, and then you will have obtained for free a separate UK trademark. And this UK trademark, at the next renewal, of course, you will have to pay the fees then to the UK Intellectual Property Office. And if you really want to go and offer your products all over the world, like Coca-Cola is a trademark that's protected almost in all countries of the world where there is an existing trademark law system. But then you can go to the WIPO, the World Intellectual Property Organization in Geneva, but also, of course, via the website. And there you can file an international trademark, and then you can designate all the countries where you would like to have your protection. And of course, with every cross you put behind a country or a territory like the European Union, the taxes will increase. And if you do Japan, United States, Europe, Russia, China, you will have to pay a few thousand euros to have your trademark protected in this huge territory almost all over the world. Now, once you have decided what your trademark is, you have to, of course, to check on the internet that your competitors are not having the same or similar sign, because otherwise you will get yourself in trouble, and they may also file an opposition against your trademark. But once you have decide, okay, this will be my trademark, I will use it for these and for these products in this or this territory, you file it, you pay the taxes, and it's registered, then you have exclusive rights. And like the copyright owner has the exclusive right to prevent others from reproducing his work or communicating it to the public, well, likewise, the trademark owner, he has exclusive rights, and he can object against the use of his trademark by his competitors. And there are 3 main categories of trademark infringement. You see them here in the yellow field. And in the gray field, there is one supplementary ground for trademark infringement that is only valid in the Benelux, but that's maybe less important for the presentation today. Let's focus on the 3 main infringement of trademark law. So what can you do with your trademark? Well, of course, the first thing, if you have a trademark and somebody is using the identical sign for identical products or services, then there is counterfeit. If you are the owner of the Lacoste trademark, because you're a French company called La Chemise Lacoste, well, if you see then somewhere in a store a t-shirt with the same crocodile and the same words, well, it's counterfeit. There's not much discussion possible. You are allowed as a trademark owner to prevent the sale of this counterfeit. Somebody else is using the exact same trademark for exactly the same goods or services. That's not allowed. The consequence of this rule, of course, is that you are allowed to use the same name for completely different products or services, because that's no trademark infringement. And in Belgium, we have the famous speculoos from the trademark Lotus, from Lotus Bakeries, but you also have Lotus as a trademark for handkerchiefs and all kind of paper products. You also have Lotus for cars. You also have Lotus for Lotus Notes for software. So these are completely different products and services, and there, of course, these trademarks can peacefully exist on the market. They are not causing each other harm. It's a completely different situation compared to the counterfeit that you see on the left. So the first trademark infringement, exactly the same products are having exactly the same trademark. That's not allowed if the trademark owner does not agree. Second case of trademark infringement is a little bit more difficult. Here we will either not have exactly the same goods or services or not have exactly the same sign. So there will be differences. The trademarks may be similar, they look a little bit, but they are not identical, or they are used for similar products and services, but not for identically the same goods and services. So in these cases, they're not always automatically a trademark infringement, and the court will have to look if there is a likelihood of confusion, because that's the standard. If the trademarks and or the products and services are too close to each other and there is a likelihood of confusion, then there will be trademark infringement. If on the other side, the court said, well, it's a little bit similar, but it's for different kinds of products and the marks are not really the same, I don't think that there's a likelihood of confusion, then there will be no trademark infringement. And I have an old example here on this slide where the mobile operator base filed a lawsuit against Mobistar, which is now, the name doesn't exist anymore, it's becoming it has become Orange. But Mobistar, the predecessor of Orange, used to have a couple of years ago, they wanted to launch a new product which was called Basic by Mobistar, or Basic with the logo of Mobistar that existed back then. And one company was, of course, not happy by that because they say, well, we are called Base. Our trademark is called Base. We are selling our products to the whole Belgian market. We are investing millions and millions every month in advertising. So the trademark is really well known. And if we then see that there are only two competitors with their own network, and one is Proximus and the other is Mobistar, now Orange, well, then we do not like that our full trademark is being reproduced in the trademark of our competitor. Because if our trademark is Base and the competitor is using Basic or Basic by Mobistar, well, then our trademark is completely reproduced in this other trademark, and there are only 3 competitors on the market, so this will really create confusion on the market because the people will think Basic, is that something to do with Base, is that coming from the same undertaking, or maybe it's a joint venture between Mobistar and Base. So people will start thinking, is there something? And if the people think that there is something, then they are confused, and then there is a trademark infringement. And here the court indeed said that there was trademark infringement and that Mobistar was not allowed to use anymore or to develop anymore its new product line Basic or Basic by Mobistar. Another example that you see here is coming from the European Court of Justice, where the court found that there is indeed a likelihood of confusion between the two packaging of olive oil, because the Court of Justice said, yes, there are a lot of differences, and in reality, if you look at the product with a loop, you see that there are all kinds of differences, but nevertheless, the court said the overall perception with the consumer will be the same. Because this is olive oil. Olive oil is a fast-moving product. The consumers go to the supermarket, they pick products quickly, put it in the shopping basket and go to the cash register to pay, and they do not pay closely attention to this kind of products. And if then the overall impression created by one trademark is similar to the overall impression of the other trademark, and these marks are used for identical products and services, then we think that there is a likelihood of confusion. We think that the consumer can be misled about the origin of the products, and therefore there is trademark infringement. So you really have to look at the kind of products. Is it a product for which the consumer will take his time before he buys it? Then it's less likely there will be confusion. If it's a fast-moving consumer product, then it's more likely that there will be confusion. And you always have to look, the Court of Justice says, to the overall picture, and the consumer will see something and he will have an incomplete memory of what he saw. And if this memory is incomplete, he can more easily be confused, and that is an indication that there is indeed a trademark infringement. So trademark infringement can exist because the words are similar or because the packaging is similar. And here in the other example of Apple versus Peer Technologies, it's the concept that is similar. So the Apple and Peer, it doesn't resemble at all, but it's the concept that is similar, and also to a certain extent, yeah, the Apple and the Peer, it's a little bit the style of presenting the Apple and the Peer is similar, but it's mainly here the concept that is the same. And if the concept is the same, there can also be a confusion, because the consumers who are confronted with peer technologies, they can think, oh, this peer technologies, it looks a little bit like Apple. It makes us think about Apple. Maybe it is related to Apple. And as a trademark owner, in this case Apple, you do not have to show that 10% or 20% of the consumers are actually being misled or confused. No, you only have to show that it's likely that the average consumer can be misled. So the threshold is relatively low. If it's likely that the average consumer for your product and service can be misled about the origin of the products, then there will be trademark infringement. And here's another example of some gray areas. This is an example of trademark infringement that was decided by the courts here in Brussels. In the first case, there was Jupiler Blue that was coming on the market with a new packaging that you see on the big picture in the right-hand side on top of the big picture. There you see the original blue packaging that Anheuser-Busch InBev launched a couple of years when they were kind of rebranding their Jupiler Blue brand. And the Jupiler Blue brand is a brand with less alcohol. The alcohol percentage is, I think, 3% rather than the usual 5% for a normal Jupiler beer. And Maas, the competitor Maas, was not happy with this new packaging of InBev because they said, well, you are using our blue. And indeed, in one of the pictures you could find on the internet, you could see that the blue of Jupiler Blue, the big can in the middle, is quite similar to the blue used by Maas. But in reality, the picture on the right, the inset on the right top, that's the real color. And the color is, in my opinion, quite different. But you see in the internet, people manipulated, in my view, the pictures to make it more favorable in favor of Maas, which is a little bit unfair. But anyway, the blue was considered by the court in Brussels to be too close to the blue of Maas, also because the packaging was kind of similar. The letters became printed in a vertical way on the can, while it used to be different. The image of the bull was reduced and was now more or less in the size of the image which is under the Maas Pils trademark. And the court found that it was a little bit too close and that the big corporation like Anheuser-Busch InBev should have taken more liberty in designing new packaging that should be much further away from the packaging of Maas. And so here there was an infringement of the blue trademark of Maas, because Maas has protection for the blue color as such, but also because the packaging itself was misleading, and therefore there was also an unfair commercial practice. And InBev lost the case, and they then designed a new product with a much lighter blue, and the position of the mark blue is now not a vertical anymore, but it's something in between. The Jupiler Bull with the red is also more pronounced, so now there is no likelihood of confusion anymore. And with this court decision in its hands, InBev itself went to the court a couple of years ago because Aldi, the retailer, was selling the new style beer in the can that you see there on the right, the Buval. And InBev said, well, if our can of Jupiler Blue was too close to the can of Maas, then definitely here it's the same. Why did Aldi produce this beer in a can with a completely red background, where they put a wild animal in the middle in black on a white background? The position of the trademark Buval is on the same place with the same frame around in red, so it all looks like a lookalike packaging. And the court in Brussels agreed. The court said indeed Aldi was infringing upon the trademark rights and the unfair commercial practice, and was ordered to stop producing his Buval beer in these cans. But Aldi did not agree, and they filed an appeal. And the Court of Appeal, surprisingly in Brussels, sided with Aldi and said that there is no likelihood of confusion. And one of the reasons that the court said is that in the end, the beer of Aldi is being offered only for sale in Aldi stores, and Aldi is not selling any Jupiler beer, and therefore the consumer cannot be misled. So it's a very strange decision, I would think, because yeah, the fact that there is no Jupiler beer in Aldi, that's not a decisive argument. It's not, first of all, because there is no Jupiler beer today that there will not be Jupiler beer tomorrow. And also other stores can buy products at Aldi, like the small corner shops in Brussels, for instance, the late night shops. They can buy their beer at Aldi and they could put it in the shelves and they could put it next to the Jupiler beer that they also buy somewhere, and then the consumer would definitely be misled. So this argument is not very strong in my opinion, but nevertheless, Aldi changed its packaging, but then they won an appeal, and now they are allowed to put the Buval back in red on the shelves, but I'm not sure they are doing it. But also here, to show that there is in some cases some gray area where it's not 100% clear who is right and who is wrong, and where you have to be a little bit lucky that the judge is on your side, because the judge has some margin of appreciation. So the first trademark infringement was like the counterfeit example, Lacoste, exactly the same product, exactly the same trademark. The second form of trademark infringement is where either one or the other is not exactly the same. So there will only be a trademark infringement in those cases if the judge thinks that there is a likelihood of confusion. If there's no likelihood of confusion, no trademark infringement. And then we have the third category, and the third category regards a special protection for marks with a reputation. And marks with a reputation are strong trademarks, are well-known trademarks, and they benefit from a much broader protection. And one of the strongest marks at this point in time is Google. Most people are using Google on a daily basis, and it's a very strong trademark for internet services. So you could think, well, it's a strong trademark for internet services. Why should I not start selling milk under the trademark Google? And I sell products Google Milk. And milk and computer services are so far apart from each other that there should be no trademark infringement. And indeed, you could say that the consumer will not be misled and will not think that the milk is coming from the same company as the Californian company who's selling these internet services. Maybe the consumer is not going to be misled, but still you feel that there is something wrong. And therefore, there's a third form of trademark infringement, which says that if a trademark has a reputation, if it's well known, it's also benefiting from protection if this mark would be used for completely different products and services. And why is that? That is why a party who's using a trademark that is well known for completely different products and services may still take an unfair advantage of this famous trademark, and it may also dilute or cause dilution of the famous trademark. It is clear, in my opinion, that if you sell Google Milk, well, you will be able to sell from day one a certain volume of milk, because people are curious to see this Google Milk. They will think about the Google search engine that they use every day and will say, this is funny, I will buy this Google Milk, it's funny. So that means that you take an unfair advantage of the reputation of the Google trademark. And if on the long run everybody would be able to use the trademark of Google for non-internet related services, for clothing, for milk, for offices, for cars, for bikes, for everything, well, then in the end, the strength of the Google mark would be far less. There would be dilution of the trademark, and it's also something that the trademark owner should not accept. So if you want to bring watches on the market and you want to use the famous trademark Ferrari, you cannot say, well, watches are not related to cars, so I can use it without their consent. No, the trademark is famous. You have to go and see the trademark owner and obtain a license. Otherwise, you will not be allowed to use the Ferrari trademark for watches. So what are the recent evolutions in trademark law? Well, AdWords is one recent evolution, but it's not so recent anymore because the Court of Justice decided already 10 years ago, but it's still, and I can see it in my practice, it's still an issue that comes up regularly. And what is the issue with the AdWords? Well, if you want to advertise your products and services, you can buy or reserve or rent Google AdWords. You go to the website of Google and you say you want to publish advertisements when people are looking for certain search criteria, and you want to put your link on the right hand side in the section sponsored links, so people know that this is an advertisement. And if you look for something, if the internet user is looking for something, well, you may have an interest to post your advertisement there. What is particular with Google is that they help the advertisers to pick the right Google AdWords. For instance, if you are offering handbags and you want to advertise your handbags with Google, you can take the word handbag, and everybody who is looking for handbag will see, depending on how much you pay, will see your reference popping up next to the natural search engine results. There will also be the sponsored links, and your advertisement will pop up there if you pay a certain percentage to Google. So Google will sell this AdWord handbag to you with pleasure, but Google will also say, well, why don't you take Prada handbag? Because we sit on a lot of data, and we have seen that people who are looking for a handbag are often also interested in Prada handbags. So why don't you buy the trademark Prada handbag? And if somebody is looking for a Prada handbag and types it into the browser, you can post your advertisement next to it. And this is actually a very good idea of Google, but who is not happy with this is Prada, because Prada says, well, Prada is a registered and protected trademark, and we have not given you, Google, the consent to kind of sell or license our trademark to these people, because who are these people in the end that will use the Prada handbag Google AdWords? Well, it may be people who are selling competing products, so they are using our trademark to sell competing products, and in the worst case, these people will even sell counterfeit products. That's the nightmare of Prada. And so people did not know, like, is this allowed that Google offers for sale this AdWords with the trademark of companies? And what about the advertisers? Are they allowed to use a competitor's trademark? And the Court of Justice said 10 years ago in one of the first cases of Louis Vuitton, Google said, the Court of Justice, sorry, said, yes, it is allowed. So the Court of Justice took a very liberal approach and said it is allowed for both. It is allowed for Google to sell AdWords with the trademarks of other parties, and it is allowed for the advertisers to reserve trademarks of their competitors as an AdWord and publish in their advertisement when the internet user is actually searching for something else. So it's a very liberal point of view that the Google decision brought by the European Court of Justice, but I think it was the right decision. If you see it now 10 years after date, it's good that this exists, and it's really a good means to create more competition on the market. And what is the effect of that? The effect is so that Google can sell anything they want, any AdWord that they want. They should not filter anything. If Coca-Cola wants to use the AdWord Minute Maid, which is one of their brands, they can do that. But they can also use Loza, a competing brand, for instance, or if they could use Pepsi Cola as a competing brand, for instance. And then everybody who's looking for Pepsi Cola can type into his browser Pepsi. Well, you will have the natural search results of Pepsi, but you will also have maybe an advertisement of Coca-Cola. And Google is allowed to do that. The only thing that Google must do, the Court of Justice said, is that if somebody is using this AdWord and they are publishing something which is an infringement of the first party's trademark rights, then Google must take down this advertisement, this offer. So for instance, if you are a consumer and you are looking for Puma shoes, you type in the AdWord Puma, then Google may have sold the Puma AdWord to somebody who is selling non-Puma shoes. But if these Puma shoes would be counterfeit, then Puma has the right to tell Google, okay, now we have seen this particular link, this particular advertisement, this is counterfeit, you should delete this link, and people who are then in the future looking for Puma should not see this link anymore. So as a general rule, Google can offer its Google AdWords service to anybody for any trademarks, but if Google is informed that in one particular circumstances there is an infringement, then this particular infringement must be taken down by Google upon notification by the trademark owner. So that's why Google now has on the website different methods where you can highlight an intellectual property law infringement to Google, and Google will then briefly review this and take away the infringing advertisement. So Google is relatively protected by the European laws, by the European Court of Justice, and so are the advertisers, because the court said, well, it is allowed to use a competitor's trademark to put then an advertisement on the Google search engines or any other search engine, of course, Bing or Yahoo or whatever, to the extent that it's clear for the average internet user that the advertisement that you place is an advertisement for your products and services and is not coming from the trademark of your competitor that you used as your AdWord. So what does that mean in practice? On a job site, for instance, if you are looking for an engineer with Proximus, and you say, look, I'm an engineer, I'm looking for a job at Proximus, you type in job offers engineers at Proximus, then you will have natural search results by Google, but you will also have the advertising results. And in these advertising results, Telenet, for instance, could say, well, are you looking for a job as an engineer? Also think about Telenet. In that case, if you click on that advertisement, it's very clear that even though you were initially looking for an engineering job at Proximus, well, you see that there's a competing offer that may be also of interest to you, and you click on that, and that is perfectly fine, because Telenet is here using the Proximus AdWord, paying even for that AdWord to Google, but they are clearly indicating in their advertisement that if you click on that, you will not be with Proximus, you will be with a competing offer. And that's perfectly allowed on Google, on job websites, on Facebook, on eBay, and so forth. So that's a liberal point of view, but I think the last 10 years have shown that this is working. Now, a new issue that is coming up these days is the platform economy. So we are all living, so to speak, in a platform economy. If you want to buy products and services online, you can go to all kinds of small websites of small sellers, but it's hard to find these. It's hard to know whether they are good or not, whether they are reliable or not. So in the end, a lot of consumers end up with the websites that are well known: Amazon worldwide, bol.com in Belgium and the Netherlands, eBay, and so forth. And on these platforms, you can not only buy products that are being offered for sale by Amazon or by Bol. No, you can also find a lot of offers where third parties are the sellers. Now on eBay, it's only third parties that are the sellers. eBay is not selling the products itself. It's other parties that are using the platform that are sellers. And also on Amazon and Bol, more and more offers are not from Amazon or Bol, but are from third parties. And if these third parties are then infringing counterfeit products, the question is, who is liable? And of course, if you see that the company is selling these offers that are counterfeit products, you can sue these companies, you can send them letters, you can go after them. It's just that there are so many around there, and it's very difficult to find them. Definitely, if they are coming from China, yeah, you have almost no means to fight these companies in China. You don't even know who they are, where they are, what their company name is, what their street name is, and so forth. So it's very difficult. So therefore, the owner of intellectual property rights, they say, well, let's not take the effort to go after all the small individual companies who are offering the counterfeit. Let's just challenge the owner of the platform. That's much easier. Then you start one lawsuit against one platform owner, and you force this platform owner to take away all the infringing offers. So that's the question that's now being discussed before many courts in Europe and European Court of Justice. And Amazon, is one of the biggest companies in the world, is of course a main target. And so they have to defend themselves, in which their argument is like, everything that we are selling under our own name is our responsibility. If there's trademark infringement, then we will have to pay compensation, we have to stop it. But we are not liable for other people who are using our platform to sell these products and services. You have to address yourself as a trademark owner to these other people. And not even if Amazon is not only offering the platform to these companies, but is also helping these companies to sell them, because Amazon is doing also the shipping and handling. You can, as a third party, deliver your products at the warehouse of Amazon, and Amazon will from then on take over your offers and will ship them to the customers. And here, the Court of Justice has said in the Cody decision of last year, well, there is no infringement by Amazon because Amazon is not the party who's doing the selling of these products. Amazon is just offering its platform, and third parties use this platform. Well, each of these third parties is liable itself for the product that it's selling. And trademark owners who complain, they have to address their complaints to those companies that are sellers, but not Amazon, because Amazon itself is not using in its own communication these infringing trademarks. There was one case of last year before the Court of Justice, and there was also a similar case here in Belgium, also against Amazon. And the case here in Belgium is regarding the famous red sole trademark of Mr. Christian Louboutin, because he has created these high heel shoes, and he has filed the red sole of high heels women's shoes as a trademark. So his trademark is the position mark with the particular red color with a certain Pantone number, and he is then filing suit against Amazon, saying that Amazon is offering these products for sale. And the court said, no, it's not Amazon who's offering these products, it's third-party sellers, and Amazon is not responsible for these third-party sellers. Louboutin must challenge these people, not Amazon itself, even if Amazon is helping with the shipping and the boxing of the products and selling them and sending them then to the end consumers. But the debate is not over. New cases have been filed by Mr. Louboutin against Amazon, and both the courts in Belgium and in Luxembourg have recently decided that they should refer the case back to the Court of Justice of the European Union, and they will see whether the Court of Justice of the European Union Luxembourg will have the same opinion as 1 year ago in the Coty decision, or well, it will add some nuances about what Amazon can and what Amazon can not do. So this is the second chapter that is regarding trademarks. So if there are any questions, we could, I could address them right
There
now.
are indeed two questions. If a trademark is registered for a jewelry brand, and 10 years later, after the registration, that brand diversifies itself to other sectors, what is the impact on the registered trademark,
Yes.
sorry.
Yes, that's a good question. The products that companies are selling are evolving over time. So you should always look at what you are selling is still matching what you have registered your trademark for. And if it's not the case, you have to file an additional registration. So if your first registration is for jewelry, and then you go more into fashion, well, then you have to, at the point in time you go on with those new products, you have to file a new trademark and file it for fashion. And then you have two trademarks in your portfolio, one for jewelry, one for fashion products. But you have to pay twice then, of course.
Thank you. Last question regarding trademark. You mentioned in an example with the olive oil that even though there are some slight differences on the packaging, that can be a violation of trademark. Um, we often hear that you need at least 3 differences to be considered as an original product. So it contradicts a little bit your example, but
Yes.
is that true, or is it just only based on common sense?
No, it's not true. It's a myth that I never heard about this myth in trademark law. There have to be 3 differences, but you sometimes hear this myth in relation to copyright law, where people say that you have 7 notes of difference for music, for instance. But that is not true. The court will look at the overall picture and will only ask the question: is there a likelihood of confusion with the consumer, yes or no? And if there's likelihood of confusion because there are 3 differences, or 2, or 1, or 0, that doesn't work. It's an examination that the court has to do itself, and there are no fixed criteria about the number of differences. And yeah, if there are a few differences and you have a fast-moving consumer product, then there is still a possibility that there is likelihood of confusion. If you have a product like a car, where people will carefully examine it before they buy, then the chances with the same number of differences are a little bit higher. There will be lower. That there will be a trademark infringement because the consumer are looking more carefully. They are less likely to be confused.
Okay, thank you. Last question. You mentioned Amazon and the fact that it's actually quite hard to protect your rights when it comes to Amazon products sell on the Amazon platform. So you said that the decision is still pending in the case of Louboutin, but
Yes.
yeah, is it a chance that in the future the products will or the trademarks will be able to protect themselves against products that are sold through Amazon, or that will be still there is a higher chance that Amazon will be still seen as just a platform that doesn't have anything to do with the products that are sold?
Yes, that's a very good question. But I knew I had the answer, but I don't, because traditionally the European legislator has said that the platforms have no liability, and the legal basis for that is to be found in the e-commerce directive, which dates from the year 2000 already. And in the year 2000, the liability of all these parties involved in internet was discussed on the European level, and the standards were set back then. And you had caching and hosting and so forth. And for hosting, the European Parliament and the Council said, well, we do not want to put a very high burden on corporations offering internet services because it will stifle competition. We have to be a little bit more liberal and see how it goes. And then companies like Amazon and so forth and Apple will be able to develop themselves, and it will be to the benefit of all of us. And so the decision that was taken back then was that these platform owners and operators are not liable. They are only liable if there is something going on their platform and they are being informed by the trademark owner, for instance, and then they have to take this down. And this is called the notice and takedown. And it exists since 2000, European Directive, and was also then implemented into Belgian law, of course. And now in December, Mrs. Vestager and Mr. Breton announced a new Digital Services Act, which is a new regulation that will partly replace the old e-commerce directive, but the principle of notice and takedown will remain the same. It will be called notice and action, which means that you do not have to verify beforehand on your platform what is going on. But if there is something and you are informed, you are notified about it, then you have to act. So also under the new legislation that will most likely be adopted in the next year or two, the principle remains the same and the liability of the platforms will be relatively small. And the reason behind it is that for Amazon, it's almost impossible to monitor everything that's going on the platform. And certainly they do have software and they do conclude agreements with trademark owners, and they can, in theory, have an agreement with Lacoste, and they can say to Lacoste, okay, we will check all these third parties offers, and we're talking about hundreds of millions of offers every day, but we will have our software running and we will filter out all Lacoste offers where we feel, with certain criteria of course, that these are probably counterfeit. And these can be filtered out, and that can definitely help, and Amazon is willing to conclude agreements with huge trademark owners. But for some trademarks, like the Louboutin trademark, for instance, it's impossible for Amazon to filter it out on the basis of software, because a trademark is so special. It is the red sole in a particular red color on the sole of a woman's shoe with high heels. And this is very difficult to see, because if I go back to the pictures, here you can see some of these pictures. The trademark you see on the right, and there the sole is very well visible, and the authentic product is the same. But on the picture as it being published on Amazon, the software cannot recognize this as a potential infringement of the trademark, and therefore Amazon could not be held to be liable for trademark infringement if third parties publish these pictures on its website. And it's not because on the left-hand side you see there Amazon, that therefore, in my view, Amazon is liable. So I think that the liability of Amazon will still be relatively safe for the company, but there are cases, there are questions being solved, and the big technology companies, unfortunately, their reputation of Facebook, Amazon, Google, Apple is not so good anymore right now as it has been in the past, and therefore it's not excluded that the judges will still reduce not reduce liability, but reduce the defense arguments of big corporations, or also like eBay, and will hold them a little bit more liable than what they are right now. But the principle as such, I think, will stay the same.
Thank you for your analysis. No more question about the trademark, so we can move on to the next and last part of the presentation regarding the patents.
Okay, let's say then a little word about the patents. And patents are also very important. And patents protect inventions. Here, the spirit that I mentioned in the first slide is very important. People need an incentive to create wonderful inventions that are beneficial to all of us. Definitely in the COVID period, it's very clear that pharmaceutical companies, they are willing to invest a lot of money in the development of drugs, only if they then at the end have some exclusive rights, and they will have then exclusive rights during 20 years, and during these 20 years they can sell their wonderful inventions to the public with, of course, a premium in price, and this premium in price will then be used to pay back the years and years and years of research and development that these pharmaceutical companies have been doing. So it's very clear that a patent is important, because if there would be no patent law, well, a lot of corporations would no longer invent, they would no longer invest the efforts, because if they do invest and they spend a lot of money and they come up with something new which is really good for the people, well, if a competitor can just then copy this without any investment cost, well, the first company will lose all the money, and next time when somebody of the employees has a good idea, the manager will say, well, we're not going to develop this idea, it's very nice, but the competitors will copy it right away, and we will lose all our developments. So this is something that we do not want, and therefore the modern legislators have created patent law. They have given exclusive and temporary rights to exploit an invention that is new, involves an inventive step, and is susceptible of an industrial application. So you must create something that is new, that did not exist before, and you must have had an inventive step to come to the solution. It's not that you discover something by accident. No, you are aware of a problem in the industry where you are working. Nobody's been able to solve the mystery or solve it in an efficient way, and you come up with a solution, and then this is something that you have created. That's an invention that is susceptible of being patented. For instance, if there is too much water as a result of the climate change and the sea level will rise, well, it could be good to collect all this water, take out the salt, and use this water to drink and to use in agriculture and for gardens and so forth. But so far as I know, at least, there is no easy way to take the water, the salt out of the water and use it then as fresh water. That doesn't exist yet. So if you come up with an idea that is very efficient, not too expensive, well, definitely you have created something new based on inventive step, because you have been thinking about these problems for years, and you are able to make a machine with that, you are able to give it an industrial application, well, then you can file for a patent. But if you discover something, you will not be able to obtain a patent. If you develop a mathematical theory, an algorithm, that will also not be protected. Designs will have a separate protection. I say a word about that later. A business method is also not protected. There has been some discussion in the United States where people said that a patent could be protected for a business method, like the one-click patent that I think Amazon had a couple of years ago, where you can buy a product just with one click because the company is collecting the data behind it, the credit card number, delivery address, and so forth. But these kind of patents are definitely not valid in Europe, and I don't remember what the state of those patents in the United States is. But in Europe, they are definitely not valid. What are also not valid is patent on animals. So the Harvard mouse that you see on the right, where the developers have developed genetically modified mice who then were on which back an ear is growing. That is raising, of course, some ethical questions. And in Europe, it was decided that you cannot obtain a patent for such transformed animals. So what can be protected? A few examples. I was in a case a couple of years ago about a patent for tram wheels. The tram is a transport means here in Brussels that people use every day, and some trams or tramways are relatively high, which is making it more complicated to enter. So Bombardier, which is now part of Alstom, developed a tram that is lower and that nevertheless is very strong and stable. And so it was huge technology that has been developed over years. And when there was a public tender by the company the land to buy new trams, Bombardier was offering this tram, of course, and our competitors are offering similar trams, but according to Bombardier, these similar trams that were offered for a lower price, and this company eventually won the bid, was then an infringement on its patent, and the case was then before the court, and the court said no, there are sufficient differences. The trams that the Spanish company is putting on the market in the agreement with the land is sufficiently different from the technical invention that is protected by the patent of Bombardier, and so these new trams are currently, I think, being developed. So products can be protected by patent law, and very important today is, of course, let's have a look on my slides here. Very important today is the protection of medicines, because medicines in COVID times, it's very clear that medicines are very important. And also here, if pharmaceutical companies invest in developing a molecule to cure a certain disease, it will be protected by patent. And most cases we see in the Belgian courts are actually cases in relation to drugs or medicines. Now, while filing a trademark is relatively easy and not so expensive, it's a complete different ballgame for patents, because patents, to decide whether or not you have an invention that is a novelty and that can be applied in the industry, and that there's an inventive step and so forth, that is not so easy to find. To be sure that what you have created is something new and did not exist before, the patent examiners at the European Patent Office will see what the current status of science is in the area where you are working in, and will then decide whether or not your patent is new and novel enough to be protected. And therefore you have to pay the patent examiners And to defend your patent, you will also need patent professionals, patent attorneys, which are people working in patent firms with a technical background. So the costs with European Patent Office will quickly be 5,000 euros or more. And then you have to pay also the fees for your own patent attorney, who will draft your patent, will defend your patent, will make the drawings, write the text, and so forth, and do also research to the novelty of your invention. So European patent is very valuable, but it's relatively expensive. If you have an invention and you are acting locally, you could also file a patent with the Belgian Service for Intellectual Property, but there your patent will be granted automatically. You will have to pay a fee, but the value of your patent will not be very high, because Belgium does not have the means to examine whether your patent is really creating a new invention. So you may obtain the patent, the document issued by the Belgian authority, but if you want to use it to sue a competitor who is selling competing products, well, this competitor must say, well, your patent is worthless. Look, what you have invented already existed here and there. Look, here in this library, you have a book from 5 years ago where you have the same description of what you have in your patent, and therefore your invention is not novel anymore, and your patent will be declared invalid. So the best is, if you have a real invention, to hire a patent attorney and go to the European Patent Office. There your patent will be examined, and then you will have a European patent, and then you have to decide in which countries you want to obtain protection. So you can have your European patent be valid in Belgium, in the Netherlands, France, Germany. You will have to pay additional taxes, of course, but then you can choose in which countries you want to invoke the protection of your European patent. And if you then have a case, your case will then be decided under German law for the German aspect of your patent, under French law for the French aspect of your patent, and so forth. The patent protection term is relatively short. For copyright law, it was 70 years after the death of the author. For trademarks, it's 10 years, but renewable indefinitely. For patents, it's 20 years. And the only exception you have is for drugs. There you can have a special certificate, because before you put your products on the market in the pharmaceutical industry, you have to do a lot of testing. And if, for instance, your testing is taking 5 years, then the remaining value of your patent will only be 15 years, and therefore you can obtain special protection with an additional 5 years maximum that can be added to your patent. So if you have defended your patent, so you have this, first of all, this wonderful invention, you have hired a patent attorney, and the European Patent Office has granted your patent, then you are protected for 20 years. And during these 20 years, you can see what your competitors are doing, and if they are making a copy of your patent invention, because they are basically selling the same product that can only be made under your patent, then of course you can prevent your competitor from selling these products. And if you have a method, because patents are not only for products, it can also be a method how to make a certain molecule in the pharmaceutical industry, for instance. If somebody are using the same molecule with the same method that is protected by your patent, you can also prevent them from using this method. Now, patent law is also causing some ethical questions more than in other areas, and the COVID-19 crisis is putting this to a sharp again, because we are all very nervous of being vaccinated here in Belgium. But what we unfortunately forget is that a lot of countries do not have the money to buy these vaccines from the international pharmaceutical companies, and that the distribution to companies who pay less is not going very well, of course. And the percentages in poor African countries, the percentage of vaccinations are not comparable to what we have in Europe or in the United States or Canada. And so there are always questions coming up. Is it fair that the patent has exclusive rights to the patent owners? And the law already provides that there can be exceptions to that, and that in the common interest, the governments could impose a compulsory license to the pharmaceutical industry, where the pharmaceutical industry is obliged to give a license to somebody else, and this other party can then produce the protected medicine at a very lower price, because the government has imposed a low royalty fee. And there's now a new movement to make use of this system that exists kind of internationally, to make sure that also poorer countries can obtain the authorization without having to pay the full patent fees, because for COVID-19, a lot of the techniques to make these vaccines will be protected by patent law. And so there is a big movement within Médecins Sans Frontières, for instance, to make sure that also poorer countries can produce the vaccine. And there's big political debate about this at this point in time. So see how this will work out. So this is for the real true invention, which is only a technical aspect to produce a product or a method to produce a product that can be protected by patent law. Similar to that, you have what is sometimes called in English a design patent. There, the focus is not on the invention itself, but on the design. And we call it, in Europe, we call it designs and models, tekeningen en modellen, or designmodel. And the right to be protected for designs is coming from local Belgian or Benelux legislation on the one hand and European legislation on the other hand. And these legislations provide that also the shape of your product can be protected. You can have exclusive rights for the shape of your product if the shape is novel and you are the first to have created this shape of your product. And a funny case, definitely for Belgians, is the case that you see there on the right, which regards an international battle between McCain, the Canadian group, and Simplot, an American company, about the form of the fries, the French fries or the Belgian fries. And Simplot, the American company, has created the shape of a spiral fry, has obtained a design for that, so it's protected by a design in Europe and in the United States. And when McCain came on the market with the fries that you see on the picture below, well, these are kind of a similar fries, and the courts in different countries, because there were suits in Belgium, France, and the Netherlands, came to the conclusion that this is a valid design right and that McCain should not be allowed, and they were infringing upon the design rights of this patent because their fries are really the same, have really the same shape as one that you see on the drawing of the protected design. So the case is still pending before the courts in the Netherlands about the compensation that McCain may have to pay to Simplot for infringement of the shape of the product of the fries. So that's important. Here for the designs, the protection is at 25 years, and you also have to register it. And if you go to the European Intellectual Property Office website, the one that was also shown in the trademark slides, there you can look for the designs. It's not so easy, of course, to find because it's easier to look for a trademark whether it exists or not than for a design, but it's possible to upload pictures and to ask the IT system of the European Intellectual Property Office whether there are similar designs out there, and then you can see whether or not your design does already exist, and you would then be infringing somebody else's earlier design. The second right related to the patents is trade secrets. Trade secrets is in a way the opposite of a patent, because a patent is characterized by the fact that you have this invention and then you want to have a protection for this invention, so you submit your file to the European Patent Office or the United States Patent Office or whatever, any patent office in the world where patents are recognized. You submit your file, and there the examiner will look at your invention, how you have described it, what are the drawings, and he will see that what you have invented, did it already exist in the science as we know it at the day of the examination, yes or no. And if your patent is being granted, it will be published and everybody can see it. You can look into the patent register. You can see all the patents that are being filed in Europe on the European Patent Office website. So all the information that you put in your patent is public. Everybody can read it. You can obtain similar protection, but with the complete opposite means, by trade secret protection. Because by trade secret protection, you have a protection that is not being revealed, that is being secret. And the advantage of this is that as long as you keep it secret, it will be protected much longer than 20 years. A typical example is the formula of Coca-Cola. Coca-Cola was developed more than 100 years as a medicine. Well, if the inventor of Coca-Cola would have obtained a patent back then, he would have written down the exact formula with the ingredients and how to make this strange drink called Coca-Cola. He would have had a protection for 20 years, and the protection would then have expired, and everybody could have seen in the patent register the recipe of Coca-Cola and could make, after 20 years, completely free of royalties, exactly the same drink. Now, what Coca-Cola did back then was not file for a patent. They said, well, let's keep the formula of our wonderful drink in a locker, and we put a special code on it, and we make sure that even within the company, Nobody or almost nobody knows the exact formula, and then it will remain a secret forever. And that is indeed a very useful way of protecting certain information. Of course, you cannot use it for everything because some things can easily be re-engineered and can be seen. But for some things like the formula of Coca-Cola or of a medicine, sometimes it's difficult to know exactly what is in there. And then you can consider it to be a trade secret and will be protected. And that means if an employee of Coca-Cola who has seen the formula, he cannot quickly make a copy with his mobile phone and send it to PepsiCo. That would not be allowed. That person would be violating the trade secrets of Coca-Cola. And you see in the internet world regularly in the newspaper stories about managers at Uber who see how Uber is working on these platforms and making efficient platforms, and then they go to a competitor where they use similar techniques for the platforms, and then there is a claim coming from Uber saying, well, our employee that went from one company to the other, he has not only taken his general knowledge that he of course has and it's free to everybody. No, he has taken really the trade secrets of our company, and we should not be allowed to do that. And then there are sometimes lawsuits following. In Belgium, there are always a few lawsuits pending in this regard, but also in other countries, obviously. So if the information is not generally known in the company and on the market, and it has therefore commercial value, then it will be protected as a trade secret to the extent that the company is investing to keep this secret a real secret. So if you have trade secrets, and everybody as company has trade secrets, how they do things in an efficient way, then you have to make sure that your employees sign non-disclosure agreements, that you need passwords to have access to certain information on your web server, that not everybody within the company has access, that everybody has access only to the projects they are working on. You have to make sure that people cannot just enter the premises and look around in your factory and so forth. And if you do all these efforts and the information is then secret and has commercial value, then you are protected against theft by employees or by third parties. So this is the third chapter on mainly on the patents, but also designs and trade secrets. I'm not sure if there are some questions here, otherwise I could answer them now before we go to the last chapter.
There was a general question regarding software protection. I don't know if it falls under copyright or patent, but how to protect a software in the United States?
That's a good question in the United States. Let me first answer with Europe, because that I know best. In Europe, software will be protected by copyright law. So the software houses, Microsoft, Adobe, and so forth, if they see counterfeit, they file suit against companies under software law. Software is considered to be an original work of authorship. In the United States, a little bit different, and I studied in the United States. I also did copyright law and patent law and so forth, but it was in the end of the year of the 90s, so I'm not sure today what situation is, but back then you could obtain a protection for software, not purely the software, but it was related to hardware. And what companies then did is they just created the software, they made sure it was tied to a hardware, and then they filed kind of a joint patent which was protecting the hardware and the software at once. But that was when I was studying there, it's 20 years ago. So if you really want to know, I'm afraid you will have to consult with a US attorney or do some research on the internet.
Another question, it's related to the medical sector.
Mm-hmm.
What happens on the trade secrets if an employee leaves a company that has a registered patent and goes to the competitor? I guess usually on the contract itself, it is stipulated that they can maybe not join a competitor or that they keep the secret. But what can you do to prevent this kind of situation and to protect yourself?
Mm-hmm. Yeah, for employees who are working for a company, we have, as we said, the trade secret protection, which was recently introduced into Belgian law, which offer protection for all trade secrets. And for employees, there's an additional article in Belgium, at least, but I assume it will be the same in other European countries. In the labor law agreement, if you are an employee of a company, you are bound by the law to respect the trade secrets of the company you are working for. if you have no competition clause in your contract, you can go from one day to the competitor, but you can only use the general knowledge that you have obtained, and that is part of your own, I would say, intellectual brains that you can use, but you cannot start making photocopies or download information from the server. That you are not allowed to. You have to leave all this information with your previous employer. And unfortunately, I see it in my practice regularly that people go to a competitor, and in the months before they leave the company, they start sending emails to their Gmail or Hotmail accounts. They start using making photocopies on USB sticks and so forth. And then when they go to the competitor, they say to the competitor, look, I'm here, I'm operational, I can work on a lot of projects because I'm really skilled in what you need for your company, and we have a completely competitive advantage as from day one. But this is unfortunately not allowed. You're not allowed to start copying and sending information to your Hotmail account, and you cannot say, yeah, but this is just general information, it's a list of the clients, but everybody knows who the clients of my employer were, and I know all these clients because I have the phone numbers of all these people. Yes, you can make a few phone calls to a few of your contacts, but you cannot copy the whole list of the clients of your current employer and use it then with your new employer. And with the modern computer techniques, what we often do as lawyers is we take then the computer system to a forensic investigator, and this forensic investigator can see a lot of traces on the computer of the employee of what was copied, when it was copied, to which address it was sent, and so forth. And the courts regularly appoint experts who then, together with the bailiff, go to the employee who left the firm without a warning beforehand, and they are allowed to get into the computer of this employee. The employee will have to give his password, otherwise a penalty will apply, and the forensic expert will then make a copy of this whole computer system, a whole computer hard drive and so forth, and he can then look whether or not trade secrets have been stolen. So you have to be very careful as an employee if you go, and the employers also have to be very careful that they make sure the employees do not steal, they don't have access to all the information, that they should not be able to copy lots of information on a USB stick and so forth.
Thank you. Last question. It's related to copyright and again the jewelry sector. What about the protection, the copyright protection, if there are partners in the UK and in the US selling or distributing the product in their own country?
Yeah. Well, the advantage of copyright protection is that there is no registration required. So if something is protected because it's an original work of authorship, it should be more or less the same standard in the UK and in the US, because both the UK and the US are part of the Berne Convention, and the main principles of protection are the same. Now, there can be some differences in practice. However, if the jeweler, if you made some jewelry that the Belgian judge finds to be sufficiently creative and original with the choices of the author, and he grants copyright protection, it may well be that the English judge is more strict and believes that it's not sufficiently original to be protected, and therefore it can be copied for free, and the same in the US. So you have then, in theory, yes, your protection will be the same. You have to do no filings, or you have to pay no fees for protection. But in countries like Belgium and France, you can relatively get protection easily, while in other countries like the UK, the threshold is a little bit higher, and you really need to have a little bit more creativity in your work before you are able to invoke the protection of copyright law. But you can always file. You can always file if you're not sure that your work is sufficiently original for copyright law protection. You can file for design protection, and then you are protected during 25 years. And then you have to file it with the UK Intellectual Property Office, and in the US also, and also in Europe. And even that's a little bit more complicated. In Europe, you also have an unregistered design patent design that is offering protection for 3 years. And this is sometimes used in the fashion industry because fashion is changing so quickly, and the companies do not always want to file and pay for new registration. And then you could say that the shape of your fashion article is novel, did not exist before, and you can then invoke during 3 years design protection without having a registration. But it's short, of course.
Design protection is the best option in this case.
In this case, maybe the best option if the design is not sufficiently original. Yeah.
Okay. That was the last question, so we can move on to the last part of your presentation.
Yes, perfect. I have 2 more slides left. One about the remedies, because of course it's interesting to know that you have certain intellectual property rights, but what can you do with those rights in practice? And how does it work in practice? In practice, if you have a creation, your jewelry, for instance, or you have a patent or a trademark, and you see that somebody else is using your creation, be it an identical creation or a very similar creation, then you can say you have to stop with this because I have intellectual property rights on those creations. And typically what you do is you send a letter first. It's not required, but often that's the way it goes, in which you explain what your rights are, what you are doing, and then what you have seen that your competitor is doing, and you publish, you copy, for instance, some web pages, or you add some photocopies of advertisement or of the product itself if you have been able to buy it, and you say, well, this is what our intellectual property rights is, this is what you are doing, so you are infringing, and you have to stop immediately because you are causing harm to our company. So first you have to stop immediately. Second, you have to tell us what you've been doing in the past, because we want to know if you have sold one of these products or 100 or 100,000. We want to know if you have been advertising this on the internet and how many people have seen it, how many brochures you have printed, and so forth. And you can then say at the end, well, look, we reserve all our rights to claim compensation, and we will calculate the compensation that is due to us on the basis of the information that you will provide about the scope of the infringement. Of course, the defendant who receives such a letter will most likely not tell you exactly how much he sold and so forth and how much advertisement he made, but he may believe that indeed there is something wrong and he will stop, and he may then offer some small compensation, and you have to negotiate whether it's worth to settle for a small amount of compensation, or sometimes even no compensation, but be sure that the infringement will not occur anymore in the future. Or if you're not in agreement, then you have to decide to go to court. Sometimes, of course, you do not want to tell the infringer that you are watching him and that you are sending him a letter and you will sue him in court, because he may be able to make evidence disappear. If you do not know how many copies of your protected trademark the other party sold, and then you can sue them in court, but you will never obtain substantial damages because you do not know how much he sold. And if you ask him to open his books and to have an accountant that will look into his books, it can be too late. Maybe the books will be destroyed or evidence will have disappeared and you will not be able to claim compensation. And therefore in Belgium, but in several other European countries, you have what is called a counterfeit seizure. And a counterfeit seizure are measures that you can obtain from the president of the enterprise court on a unilateral request ex parte. The other side, the alleged infringer, will not be informed about this. And this is a very powerful tool if you see something on the market in Belgium, but it also, as I said, exists in the UK, also in the Netherlands, in France. So you can go to the judge and tell the judge, look, this is my intellectual property. This is what I've been seeing on the market by this and this competitor. We want to obtain the permission to go to this infringer and to look into his warehouse. How many products does he have? Where does it come from? To whom is he selling? What his margins are, and so forth. And then the court can grant this request, and normally the court should grant this request. And then you will be able to go to the premises of the infringer with an expert that the court has appointed, and with the bailiff. And the bailiff and the expert can enter the premises, can open doors, can even unlock a lock if something is closed in a warehouse, and so forth, and can then make an inventory of what you have. How do the products look like? Is it probably an infringement, yes or no? How much have you sold? To whom have you sold? To which countries have you exported? And so forth. And on the basis of this report, you can then file suit on the merits, in which you can really claim the damage that you have, compensation for the damage that you have suffered. So this is a very powerful means. You have to be careful, of course, because people can sometimes say it's not an infringement, and the court can then receive an opposition against the measures, and the court can withdraw the initially pronounced measures. So the recommendation generally is that you can obtain these measures to describe the alleged counterfeit, to collect evidence about the infringement. But you can in Belgium also obtain a seizure order to block all the products, and that is also normally granted by the court if you have valid rights. But But there you take a risk that you block the whole stock of your competitor, and if then later on you lose your case on the merits, then you will be held to pay damages because you have blocked your competitor with an ex parte decision, and that could be very expensive. Therefore, it's more, in most cases, more prudent to only obtain the evidence measures and not to block the stock of your competitor. And with this report, then you can file proceedings on the merits, and it could be proceedings on the merits, as you see here under number D, to obtain damages. These proceedings are in Belgium often brought before the commercial court or the enterprise court, and it takes 1 year often before you have a decision. Or you could also go for injunctive relief proceedings, action en cessation, stakingsvordering, or in some cases also interlocutory injunction with summary proceedings to obtain a decision relatively quickly as a preliminary measure. And in point D, there you can obtain damages. In point C, the proceedings, you can obtain an injunction, which means the court will find that that you have valid rights, that there is an infringement, and that the defendant has to stop any further infringement. Otherwise, a penalty will be due of, for instance, 10,000 euros per day or 500 euros per product sold, not in compliance with the judgment of the court. So these are two different proceedings. One is going relatively fast. That's the injunctive relief proceedings. But unfortunately, in Belgium, relatively fast means often several months before you will have a decision, but that's relatively fast. If you have more time, then you can just initiate proceedings on the merits. You can also obtain an injunction in those proceedings, and at the same time, you can claim compensation for damage that has been caused. And these proceedings take a little bit longer there. It takes often about 1 year, with always, in all cases, of course, a possibility of appeal. If you are really confronted with bad faith, counterfeit, then you can also file a criminal complaint. If you see that your products like the t-shirt of Lacoste are being sold in certain stores, then you can also file a criminal complaint, and then the public prosecutor may send out the police to block all the counterfeit and bring the case for the criminal court. But then it's the public prosecutor who is in charge of the matter. And also here, the public prosecutors have other priorities than fighting counterfeit. So these proceedings can take years and years before they are becoming before the court. So we should go to the last slide. Is it not moving? Okay, now it's moving. So the last slide, it's almost, it's 3 o'clock, so I will wrap this up in a few minutes. So if you have intellectual property rights with your company or you are the creator yourself, best is to always have written contracts to exploit these rights so that it's clear what has been agreed upon, what should be paid for which way of exploitation. There's a lot that you can do yourself. You can check the trademark registries, you can check the design registries online. A lot is available that you can do yourself. You can also file yourself. If it's a little bit more complicated, you can, of course, be assisted by lawyers, trademark agent, or patent agent. That's always helpful, but it's not always required. If you are hesitating, well, sometimes it's better to have one registration too many than one too little. So if you are in the business of jewelry, but you also want to expand your product line to clothing, well, then it's best from the day one to already obtain protection also for clothing and not wait 10 years later when you go into that market. Better start a little bit earlier, not too early, because otherwise your mark may not be valid anymore. But yeah, you can at least go 5 years ahead. Then you should monitor the market for infringement. Every once in a while, look on the internet, type in the name of your trademark on Google and see what appears so that you can see if something is not right, that you can act as soon as possible. You can contact the infringer and find a solution. You can, of course, send an aggressive letter or do a counterfeit seizure, but you'd also take a more liberal, friendly approach and see with the infringer what's the problem, and maybe he can take a license in the future, you never know. And then, of course, if nothing works, you cannot find a solution, you can always go to court. In Europe, in Belgium, a lot of courts are specialized in intellectual property law. You can have good decisions, sometimes even in relatively short periods of time, but it will be relatively expensive. Intellectual property proceedings costs in Belgium a quick 10,000, 20,000 euros. And in other countries, Germany, France, and Netherlands, definitely UK also, it's even much more expensive. So these are a little of my comments that I had to say. If people need more information, they can always contact me via email or per telephone or look on our website. I've also written a book about marketing law, and in this marketing law book, it's in Dutch, so maybe it's not good for all of the people attending this conference. But in this book, there's also a chapter about trademark law and copyright law, so it can also be helpful. So this is the end of my presentation. I would say thank you very much. And if there are questions also about the last chapter, I'm still available to discuss a few more questions.
Yes, thank you for your presentation. There is indeed one last question that we can take because we are running out of time.
Mm-hmm.
And it's something about the court's interpretation that you already mentioned, as different courts might have different interpretation regarding the intellectual property. And also within the same courts, the interpretation can differ. So one participant has a little trouble with courts in Turkey, as they have different interpretation regarding patents than the ones that are common in Europe. So how to deal with this different interpretation related to different courts, and how to better protect your rights, actually.
Yeah, on the international level, it's more a political question than a legal question. You see that in your example, probably with Turkey, but you also see this with China. You've also seen this in the past with South American countries. And there, I'm afraid the best solution is on a political level in the World Trade Organization, for instance. There is a special treaty which is called the Trade-Related Aspects of Intellectual Property Law, the TRIPS agreement. I mean, all the parties, all the countries who are a party to those agreements have to comply with the principles and have to offer patent protection, so that the patent protection is more or less harmonized all over the world with all international trading nations. But if then it appears that the courts in Turkey take a different position, probably to protect the interests of their own companies or their own citizens, then yeah, you have to contact, I think, the Ministry of Foreign Affairs and say, look, we are a company in Belgium or in France or in the Netherlands, and we see that we are not prevailing before the Turkish courts, even though Turkey is a party to the GATT, the World Trade Organization, these famous TRIPS agreements. So Turkey should respect the patents of our company. And then on a higher level, I think the government should be in contact with each other and should claim that these patents of the citizens from the one country of the claimant should be respected. But it's not a legal question, unfortunately, it's a political question.
Yeah, that's unfortunate, of course. And if people have that kind of problems, they can still contact us at hub, and we can also pass these problems through the foreign affairs and discuss it on a more political, diplomatic level. So that's it for the question. Thank you for your presentation, Mr. Heremans. It's quite a challenging and tricky material, the IP law, but I think you made it clearer to our attendees. We will pass the slides to the participants. So you receive it by email, either today or tomorrow. And the next export talk will be on the 20th. It will be on hiring staff for your exports. So please do not hesitate to register. If you have any question, you have my email address on the bottom of the current slides. And thank you again for the presentation and your time, and good afternoon to everyone.
Okay. You're welcome. Thank you very much. Bye-bye.
Thank you.